Oh shit. Yeah, literally. Yeah. All right. All right. Yeah, yeah. So yeah, I guess this is really the only mode I have of communication, and I wonder what I'm foregoing by streaming on YouTube at this point, because I'm suing YouTube LLC, um, and I'm aware that I'm not aware of any specific reason why I wouldn't be able to stream on their platform in the interim, but I'm also not a lawyer, and I'm not as studied as I would like to be. Well, no, actually, I'm fine with who I am. I actually believe in ethics, and I believe in the truth, and I believe that the truth is important, and I believe that taking action when you have been misled or defrauded is important. And I believe when you've been harassed or cyber stalked, to take action is important, especially because the intentional infliction of emotional distress is when you're being harassed online repeatedly, is a pretty easy statute. It's pretty easy to prove that there's intentional infliction of emotional stress if you've been through what I've been through. Um, YouTube is something I started. I think I started streaming around 2016, and starting in 2021, an issue arose from my duti- uh, dutiful uh, application of the First Amendment, which is to speak my mind and to say what I think and what I feel, as well as to be a good Samaritan and prevent the intentional infliction of emotional distress on others. And so I did so, and by making claims about one certain person who I'm not so sure YouTube doesn't have a duty to uphold estoppel, against, because I believe this person has had channels taken down. Um, this person flagrantly violates my my copyright, and uh, and this person continues to harass me, even though there is a lawsuit that he's aware of, for which he's been served. He will be served again with a different form, provided that the court doesn't recognize the Sum 100 form as a valid service. Um, if it does, which Mr. Schultz, myself, I will inquire. If it does, then he will have to answer by the end of the month, essentially. Maybe that he has one day into the next month. Uh, and unfortunately, there are other individuals who defrauded me uh, on behalf of major companies, defrauded me and led me to believe. Uh, let's see what the statutes of fraud are. I have them right here. Hold on. I am not like if I have a lawsuit against you, just I'm going to sue you. That's that's who Todd is. And so what is fraud? The suggestion as a fact of that which is not true by one who does not believe it to be true. The positive assertion in a manner not warranted by the information of the person making it of that which is not true, though he believes it to be true. Positive assertion in a manner not warranted by the information. Person making it of that which is not true. So positive assertion in a manner. Okay, so that basically means if you say something like Putin invented Bitcoin, you can be sued for fraud if people based on that invest in Bitcoin. Because not because it's not true. I mean, because when you talk about truth, who the fuck knows? But because there's zero evidence supporting that. 3, the suppression of that which is true by one having knowledge or belief of the fact. Any other act fitted to deceive. So there you go. That's what fraud is. Now, I would say that there's fraud and then there's fraud, right? There's like I tricked you into buying a $3 lemonade, and then there's fraud into thinking that the company you were spending $2,000 a month on was going to sell for a significant amount of money and uh, uphold a business model that you did not believe to be true, I suppose, is the particular case of fraud I'm speaking of. So there's also like, okay, where's YouTube fraud? Where's YouTube being fraudulent? YouTube terms of service. And look, I'm gonna sue you if I can. If I can sue you, I'm gonna sue you because I don't believe in lying and tricking people when their livelihood or emotional and physical well-being is on the line. I think it's fraud. It is fraud, as a matter of fact. And whether or not you, now in retrospect, have other opinions of which you did not disclose at the time, but that you think entitle you now to pretend that you weren't being fraudulent in the previous time, no, you still were. You can't make shit up now to cover up for your fraud back then. And the fact that you made shit up now is actually another instance of fraud. Right? It's because the reason being is that you're likely saying things which are contradictory to what you said years ago. Right? So what does that mean? It means that you were saying years ago you thought this, and this. And then 2 years later, you're saying, no, I didn't think that, or that. And so, in a sense, both situations become fraudulent. You become fraudulent. You become fraudulent, a fraud. And thus you have defrauded a person. And let's see, there's also, just for all those people out there that like to bring up like addiction and drug use as a way to discredit me. Let's see. Character no longer refers to shameful or bad character. It refers to all general traits, good, bad, and morally neutral. It refers to all evidence, even evidence the defendant himself introduces. Okay, good. Let the defendant introduce it. Applies in civil and criminal cases, and to all witnesses, which I have witnesses, and parties. Habit is the regular practice of meeting a particular kind of situation with a specific type of conduct, such as the habit of telling Todd Michael Schultz you were going to buy his company when in fact, well, you were, except Todd Michael Schultz decided to, well, in my opinion, decided to ask for more than you were willing to give. Um, or otherwise, which, the defendant can speak for himself. Um, but the specific type of conduct, such as the habit of going down a particular stairway, 2 stairs at a time, or the giving the hand signal for a left turn, or of alighting from railway cars while they are moving, which means like, I guess it means like going on train tracks and then running away when the train comes. The doing of habitual acts may become semi-automatic. Okay. Character considered more prejudicial and less probative. What does that mean? It means that it's less, you can't really litigate character as such defined by what I just said. But you can, it's prejudice. It's prejudicial. It's not, it's non-probative, meaning it's not subject to a probate, which is, what's a probate? Let's make sure we look up the word. What does probate mean? The official proving of a will. The official proving of a will. Okay. So basically, probate means what was purported by any given party, so to speak. Okay, so back to this. So how modern courses treated evidence of addiction? Because I'm not gonna fucking sit here and pretend I haven't been called an addict or characterized that way, because that would be a lie. And I don't lie. Addiction is character evidence. Car accident case. Plaintiff seeks to exclude evidence and argument indicating that plaintiff is a drug seeker or a pill popper or other similar reference because of plaintiff's alleged addiction or improper use of pain medications. Defendants state that they want to introduce evidence on plaintiff's misuse of pain medications on the issue of plaintiff's failure to mitigate damages under the theory that plaintiff does not follow the orders of treating his doctor. The court finds that the evidence and argument regarding plaintiff's addiction or misuse of pain medications is improper character evidence prohibited by Rule 404. So, Mr. Thompson, for you, and Mr. Lowry, now for you at Deerfield Marketing, who just insinuated that my cocaine use was a factor in the sale of Game Check, an invention of myself. You both have tried to employ my addiction or misuse of pain medications as character evidence, but it's improper. No, it is improper under Rule 404. Addiction is not habit evidence. In a civil case, pedestrian was killed by driver while walking in the middle of the road. Defense argued decedent was comparatively more at fault because she was drunk and this is a lot more like what I'm going through. So YouTube and et al., I guess, or Michael Thompson and Gregory Holmes, let's see. Plaintiff's counsel argued that this was improper, which was their drug addiction. The pedestrian was killed while walking. Defense argued that decedent, which is the person that died, was comparatively more at fault because she was drunk and had a drinking problem. Plaintiff's counsel argued that this was improper. Defense argued that it was not habit evidence. Court said it was not habit evidence. So therefore, Pat, or Mr. Lowry at Deerfield Marketing, you cannot state now that any such drug addiction is evidence for anything, basically. based on what happened 2 years ago. And that's the case law. Evidence of, let's see, addiction often comes in as motive. Exactly, I know it does. Evidence of defendant's methamphetamine use on the morning of the killing and for the previous 8 years or so years was relevant to the defendant's angry state of mind when he stabbed Nava and his motivation for the stabbing. A defendant's anger towards the victim can provide motive to kill. The evidence was now challenged. The evidence now challenged was not simply bad character evidence, and it was relevant and admissible for the purpose of explaining a source and the intensity of defendant's anger. Okay, so they're saying drug use was the motive for the defendant's behavior or the plaintiff's behavior, either. Well, let's see what the court say. Defense counsel asked, "How long has your mother been addicted to drugs?" State argued this was impermissible character evidence. Defense counsel stated, "I haven't asked any questions about character. I've asked about knowledge of physical problems and whether or not she has an addiction. That's all." The dissenting judge. Addiction is a recognized disease, and nothing in the record indicates that Richard possessed any specialized knowledge on the subject of addiction, which neither did Mr. Thompson, Mr. Holmes, YouTube LLC, or Mr. Lowry from Deerfield Marketing, for that matter. Therefore, I do not believe that Richard was competent to diagnose the appellant as a drug addict. Yeah, which none of you are either, as a matter of fact. None of you are. None of you actually can even, that won't even be permissible. So I would strike that from your subject, your whatever dismissal bullshit you're trying to put forth. That was the dissenting judge. So that means he was saying, like, in my opinion, based on what I read, that you just can't say, "Oh, you're a drug addict. That's why you're on cocaine." We can't do business with someone who does cocaine all the time. Well, are you authorized to state such a claim about a person? Um, and even if you are, I don't believe it's permissible anyways, because to be quite honest, I'd rather not argue why someone calling you a drug addict is impermissible. I'd rather argue why being a drug addict is impermissible, even under a preponderance of evidence. Because what does it suggest? That a person on drugs doesn't know what they're saying, right? So it sort of it seeks to deprive a person of their autonomy or beliefs or the truth. Courts have been correctly reluctant to admit evidence that a person is a habitual drunk or has, and which is what Mr. Thompson told Sergeant Hines multiple times on body cam footage that will be forthcoming, or has a habit of reckless driving or smoking a joint every morning, because such evidence may be more prejudicial than probative, which means true, or it means that you can state that it's true. Basically, I'm pretty sure that's what it means. Probative, yeah, I meant like you can sort of will it or state it or whatever. Okay, someone just said, ooh. If the party is unrepresented, I'm on a tangent. I'm digressing. The paper must state the sentence. Right, you do not, yeah, yeah. An unsigned paper. Okay, good. Now, cause like, I still have some time. So which paper? So, like, the thing about suing is that you can continue to amend and amend, provided that the court gives you leave. And I think in a pro se excuse me, the court is designed to uphold the law, and the law is designed to uphold ethics, and ethics are doing the right thing and telling the truth. And if you're lying for, let's say, because you want to get close to an author that you admire, then you are being fraudulent. If your intent in engaging in negotiations or in otherwise good faith business discussions is actually because you just want to get close to the person that I'm with, which seems potentially likely. But even if not, it's not a moot point. It's evidence, and it's something that will be you know suggested by myself, provided that I have to sue. Okay, representative court. It is not being presented. Oh, okay, okay. So this person that has claimed that Rule 11 is an issue with me is suggesting, I'm assuming, that I am presenting my motions and complaints to the court for an improper purpose, such as to harass, cause unnecessary delay, or uh, needless increase of the cost of litigation. False, not true. The claims, defenses, and other legal contentions are warranted by existing law or by a non-frivolous argument for extending, modifying, or reversing existing law or for establishing new law. Okay, that's an interesting one. The claims, defenses, and other legal contentions are warranted by existing law. Let's see, where is it? By presenting to the court a motion, whether by signing, filing, submitting, or later having an attorney or unrepresented party certifies that the best of knowledge, information, and belief formed after an inquiry reasonable under the circumstances. It is not presented for any improper purpose, which is not. The claims, defenses, and other legal contentions are warranted by existing law, which they are, or by a non-frivolous argument for extending. Yes, I read that wrong, because my reasons are for a non-frivolous argument for extending, modifying, or reversing existing law or establishing new law. The factual contentions have evidentiary support. Of course they do. I wouldn't sue if I didn't have evidence. If specifically so identified, will likely have evidentiary support. Yeah. Yes, of course. Dude, I would not sue somebody frivolously. I would not be so stupid. I care about my fucking self. The denials of factual contentions are warranted on the evidence, or if specifically so intended, are reasonably based on belief or a lack of information. No. What's a factual contention in this instance? Not totally sure on that. Honestly, whoever you are, I mean, if you're related to Michael Thompson, then you might. Okay, you just told me. You said 11B. Okay, 11B. Okay, yeah, okay. Guess what? You're now intimidating a witness or plaintiff, mister, because I don't fall under any of these, and my lawsuit doesn't either. What makes you think I would put the type of effort and energy and uh, you know, uh, like what makes you think as a reasonable person I would do what I'm doing, risking my life, essentially, my livelihood, risking my everything, just so I could hurt another person? I don't know what makes you think that. Maybe that's how you conduct business. I certainly myself do not. And so much so do I contend that that is not the case, that I am willing to sue and thus put myself in jeopardy of being in violation of Rule 11B. The court they could impose an appropriate sanction on me because I'm basically the lawyer or a party that violated the rule, which I didn't. Um, there's seriously no possible way that will ever be argued positively because of the preponderance of evidence of me being in duress, me attempting to ameliorate the situation, fix it. Unless you want to argue that I intentionally suffered for years so that I could fuck you guys now, go ahead, go argue that. Do that. I mean, I'm not saying you don't deserve to be fucked, but I'm saying, how could you imagine a human being even capable of such behavior? I mean, suffering for 2 years to get back at somebody? I mean, at what point does the suffering become untenable? Pretty quickly, I would say. In my experience, the suffering that I endured became quickly untenable. Quickly, within a month or two. Very quickly. And I asked that it stop. You got anything else? Any more responses? Berkeley 223? Because, who the fuck are you? You're not a lawyer. You're not a lawyer. You don't know what you're talking about. You're not a lawyer. You can't understand. Also, it also is in line with the abundant amount of evidence suggesting what plaintiff. I'm going to look this up. Plaintiff intimidation, because the plaintiff is a witness in a manner of speaking. It's impossible to deny that. Ooh, intimidation plaintiff. Yeah. So I'm a witness. I'm a plaintiff. I'm witness to my own testimony, and this repeated argument put forth suggests that after I've already dutifully, and diligently said it's not the case, you're gonna have to prove that. Okay, prove it. Tom Baines Civil Rights Act. If a person, whether or not acting under color of law, interferes by threat, intimidation, coercion, or attempts to interfere by threat, intimidation, or coercion, which would be citing a frivolous statute for which you have no reasonable justification to assume, based on the fact that you're not even a party to the suit, or if you are, even worse. Um, I would say it's pretty vexatious. Um, with the exercise or enjoyment by any individual or individual right. Attempts to interfere by threat with the exercise or enjoyment by any individual or individual of rights secured by the Constitution or laws of the United States, or of the rights secured by the Constitution or laws of this state. The Attorney General or any district attorney or city attorney may bring a civil action. Call the district attorney and tell him I'm doing this, right? Or that oh, wait, you're doing this. I forgot. Will call. I will call, actually, right now. Do I call the Attorney General of the United States of California? We'll try it. Rob Bonta. He better have got a phone number. I hope he does. Do not call. File a complaint. Okay, I'll file a complaint. Okay, yeah, this is not anything to do with what I meant. Like, I'm gonna exercise every single legal avenue I have. Okay, I have to report the crime. Let's see if this does anything. I believe both Mr. Thompson and Mr. Holmes are both engaging in this behavior, by the way. And possibly YouTube, but I don't really have a preponderance of evidence, so to speak, to make the claim. But I also know Mr. Thompson told an officer that I was high, and thus he shouldn't listen to my testimony, essentially. And he was a great guy, frankly. Mhm. So, like, I'm like everyone that did something is gonna. I'm just gonna sue whoever I can, not frivolously, but with good intent. With the intent that, hey, stop fucking with me. Like, don't fuck with me. Don't fuck with me. Colloquially speaking, it's inappropriate. It's against the law in many cases, and I am not afraid to litigate at all. What the hell did I hear? 3 3. All right, there. I just reported the intimidation to the attorney general, and I mean, I'm not sure that he's not going to tell me that not to take it elsewhere. That's kind of what I've been told before. But hopefully, he will. I don't know. Hopefully, that's the right venue for that complaint or issue. Uh, there's just too many people out there that just they're frivolous in their behavior, and they don't care about the impact of their frivolous behavior. They don't care about what it does to a person, and they don't want to take any responsibility for it. And they also are under the belief that they don't have to, because that there's no way to prosecute them, or you know prosecute or address what they're doing is rather, I think the better term for now. I mean, it's just like, how much should a person take in bad faith before they say, hey, you can't talk to me that way, or you can't do that. It's not ethical. Like how much? What's the amount? At what point does it become untenable? In my opinion, it's very untenable very quickly. It's already untenable and has been so. And I'm I'll just go pick it up, whatever. They're closed. All right, well that goes out the window. But honestly, I tend to lead and inspire people, and if you've got to sue, you got to sue. It's not an ideal situation, but if you're in the right and you give it thought, and you address all the concerns, your own concerns, like what's your part in it, and you come to the conclusion that what happened is highly unethical, well then you should do what you can. If you are willing to stand by that, then you should. That's how we keep people from doing shit that way in the future. Is that a violation of 11B? I think that was the opposite, but yeah, I think it was the opposite. I'll just go with that. And if I'm wrong, if my oh god, look at all this crap. Look, I mean, like, you don't have to like me, but typically when you don't like someone, you just leave them alone. Like you don't harass them. Like you don't harass them. You just kind of leave them alone. But I guess some people don't want to do that. And I'm glad to get off my chest to state it. Just because for me, long term, it's unhealthy if I don't. It's really unhealthy if I don't sort of state my truth. If I just sort of pretend and then I allow myself to buy into not I guess not truths, you might say. Um, it causes me irreparable harm, and I'm not willing to really harm myself anymore in that way. Not in that way anyway, because I happen to respect myself and I respect my memory. I respect my memory, and I don't respect people that defraud me or abuse me. And I know, and I forego relationships with my family because of my behavior, and because of my behavior is based on beliefs, and my family does not agree with my beliefs, which is, I guess, they think that I'm a piece of shit, I guess, and that I shouldn't be entitled to anything really. I mean, like, it's just, I guess, I don't know what it is exactly, to be quite honest. I'm not quite sure. I'm not quite sure what it is that I'm supposed to contend or be okay with. And how much am I supposed to? How long am I supposed to continue to gaslight myself? And how many people does it take to gaslight me for me to say, okay, I'm wrong? And then that's the problem. Pick up? No, I don't pick up. Brett smokes cigarettes, Soledad. You fucking stalker. You fucking stalking piece of shit. How many times are you gonna abuse him? And by virtue of him, me. You fucking crazy fucking bitch. Stop contacting us. You're not welcome to. You're a piece of trash, in my opinion. For what you've said and done, I will make sure that it stops at some point. You will not continue to do what you're doing. Even if you think you're going to keep getting away with it, you're not going to. All the fucking letters that you sent, all the emails with the fucking nonsense and the cease and desists. You're a fucking, oh, no talent. Shut the fuck up. What does talent have to do with any of this? Fraud. Fake play piano. What does that even mean, fake play piano? Okay, because I'm faking playing the piano. Oh, indigo party monsters. You ki you kind of have a cadence or a type of speaking that's similar to Dashton. In fact, it's very, very similar. And I don't, like I'm taking screenshots. So, oh my God, there's so much fucking shit. So I've already reported you for intimidating plaintiff, and this will be the evidence that I provide. If it is Dashton, if it is that guy Dashton, then is it? Are you when you? Like, what am I supposed to do here? What am I supposed to do? Not stream. I'm supposed to not stream. I'm supposed to not pursue myself. I'm supposed to shut myself up. For the sake of who? Nietzsche elf? And let's see, I'm gonna report it. Let's see what happens. I'll report this person. Where's my caretaker? Who cares if Brett is my caretaker? He's a great one if he is. God bless him. Fucking love him. He's my favorite thing on the planet. And I would do anything for him. Absolutely anything. I stressed out zombie. I mean, it's my right to be stressed out if I want to be. It's not your right to fucking tell me what to fucking do. I want to, yeah, that's Dashton. I wonder who Dashton even is because obviously he used to spell I because he's some weird shit. What the fuck is going on with you people? I kicked a cat last year on stream. Is that true? Did I kick a cat? No, I did not kick a cat. I happen to love cats. So I don't think I kicked a cat. I mean, I don't even remember being around many cats in the I don't know if I even saw like was around even one cat in the last year. So like, I was spent most of 2022 in my apartment alone because of this. Because I couldn't pursue, anything because every part of my online life, which is the method of pursuing one's uh, especially entertainment related career. um, I wasn't able because this is what happens when I do. Because I've been through shit, and when I talk about that shit, well, then you have Michael Thompson saying, "I told you never to say my name ever again. Now I have no choice but to defend myself." By what? I've already like talked to several lawyers, or actually, most of them were the two of them were just doctors, not lawyers. They did not pass the bar, but they opined upon my request that there was no copyright fair use going on over at whatever. Um, I don't know. It's all just a bunch of bullshit, I guess. I'll see you soon, I guess. I mean, I don't know. I mean, like, I don't. I know I'm not allowed to speak seriously. I don't know what I'm supposed to do. I'm supposed to. Like, everything's a mockery, I guess, right? Everything's a joke. Everything's a joke. So when someone, is serious, they're, abused for it. So whatever.